our distinguished guests, ladies and gentlemen, you are most welcome to this very important activity. My name is Daniel Ruhweza. I'm a senior lecturer at Makerere University's School of Law, but in this context, I am chairing the cluster on rule of law and strategic litigation of the Uganda Law Society. We will kindly stand up and at least, I don't know if our people can help us to play the national anthem, and then we shall begin. Looks like they are not ready. Thank you very much. I'll say a brief word of prayer. Almighty God, we thank you for this time. We pray that you will give us wisdom to articulate these very important details regarding the rule of law and this launch. May we have a fruitful discussion in Jesus' name. Amen. Thank you very much, ladies and gentlemen, distinguished guests. Right now, we are, I think, operating in full capacity. We are going to start off by, we would have ideally wanted to introduce ourselves, but we are running out of time. We are going to start immediately by asking the acting Chief Executive Officer of the Uganda Law Society, Ms. Mabel Nimwesiga, who will give us her welcome remarks and also inform us about the existing protocol, and then we shall move on. So Mabel, please, you are most welcome to do that. Thank you.
Thank you, Dr. Daniel. The Ambassador of Germany, His Excellency Matthias Schauer, the Solicitor General, Mr. Francis Atoke, the President of Uganda Law Society, Mr. Bernard Oundo, the Head Legal CID, Senior Superintendent Isaiah, the Senior Technical Advisor, Gels, Ms. Rachel Musoke, the representative of the Royal Danish Embassy in Uganda, Ms. Gladys Nairuba. Ladies and gentlemen, good morning to you all. I take this opportunity to welcome you and to thank you for gracing this opportunity and honoring our invitation to the launch of the second quarter Rule of Law 2024. For the last 6 years, Uganda Law Society has been steadily dedicated to release quarterly Rule of Law reports, and today we are launching the second quarterly Rule of Law 2024, and it's the 28th quarterly Rule of Law. I acknowledge the great support we receive from all of you, especially from ULS Council, led by our President, Mr. Bernard Oundo, our donors, our development partners, our stakeholders, including our membership. I do recognize your presence today. Your support and contribution is instrumental in enabling us to fulfill our statutory mandate, especially in the promotion of rule of law and human rights. As we shall be seeing, today's report highlights the positive developments in the promoting the rule of law. It also sheds light on areas where we concentrated that we still need more efforts required to foster a more just, democratic, and rule of law binding society. I want to thank all of you for attending today, and also to thank our members attending online once again. Thank you so much.
Thank you very much, Mabel. Very quickly now, I'll ask our president, Uganda Law Society, Mr. Bernard Oundo, to come and give us his opening remarks right now. Thank you.
Thank you, our head rule of law. Let me first of all say a good morning to you. Good morning. You've not had enough tea. Do we need to ask our service provider to ensure that everyone has tea? The Solicitor General of the Republic of Uganda, Mr. Francis Atoke, the Ambassador of Germany to Uganda, the Senior Technical Advisor, Jelos, the Head Legal CID, all our representatives of the donor community who are here, I want to acknowledge you, and I want to thank you for coming again to launch our second quarterly rule of law report for 2024. As you know, for the past 6 years, as the acting CEO has mentioned, Uganda Law Society has been compiling quarterly rule of law reports which inform the state of the rule of law in Uganda. I am pleased to highlight some notable achievements documented in this report, because one of the things that we have been constantly sometimes criticized is that sometimes we don't acknowledge the positive steps that the government takes in terms of strengthening rule of law. So I want, at the first instance, to acknowledge the notable achievements that have been achieved in the last quarter. First is the judiciary commissioning the new Supreme Court and Court of Appeal buildings. I think we must applaud this. We must applaud this. We believe that the two appellant courts will contribute to the increase of access to justice in Uganda, and we must thank the government and the judiciary for being able to complete these new buildings. Secondly, we have also seen that the magisterial areas instrument has finally been gazetted, and therefore we have new magisterial areas, meaning that people can be able to access justice at more courts. So I think also that needs to be applauded. We also want to acknowledge the government taking some efforts to fight corruption. We want to acknowledge that some steps have been taken. We have seen the arrest of MPs. Doesn't mean that they are guilty, but we appreciate the positive steps that have been taken in terms of trying to fight corruption. And so we also must acknowledge that. Please, let's applaud the government for these steps. That with said, we have noted rule of law breaches during the quarter, and would like to mention these are mentioned actually in the report. One is the threat to academic freedom. I think this came out in the quarter, the threats to academic freedom. We need to highlight it as the Uganda Law Society, and we have been very clear in defending the right to academic freedom. So these threats to academic freedom are uncalled for, and that is one of the threats. Number two, the delay in hearing and determination of complaints by the Uganda Human Rights Commission. That is also significant. The Uganda Human Rights Commission is set up to ensure that complaints on human rights are received and disposed of in a timely manner. But from the report that they gave, you can see that there is delay in determination of complaints by the Uganda Human Rights Commission. Three, and more importantly, is the continued prosecutions under the Computer Misuse Act CAP 96. And notable cases include Mr. Mubiru Ayub, who was convicted of cyber harassment and hate speech, Mr. Habib Buembo, who is charged with malicious information, the TikToker, Edward, who was recently sentenced to serve 6 years in prison, and Mr. Anderson Borora, charged with malicious information and hate speech. As Uganda Law Society, we have taken a step and we have filed an application before the Constitutional Court to stay the continued prosecution of citizens under the Computer Misuse Act. We also have the violation of the right to freedom of assembly. For example, with the arrest of Ms. Fatuma Nansubuga, a resident of Kalere Market, Kawempe Division, who was staging a lone protest outside the Parliament of Uganda with just a placard, and she was accused of the offense of nuisance. We helped in representing her before the court, and the court was able to give her bail. But we appeal to government to respect the right to freedom of assembly. We also note the increase in sexual and gender-based violence. We also note the brutal attack and assault of journalists in the course of their duty, and generally the violation of the right to press. We also note the abduction of MP Akamba after release on bail. And I think for some of these things, we have come out strongly on them as Uganda Law Society, and we have issued statements emphasizing the fact that we need to respect these rights. So this report also presents recommendations which are made to the various stakeholders as per the previous report. And I wish to express our heartfelt gratitude to our development partners, donors, council members, the public, and everyone for the support in helping promote the rule of law. Your contributions have been instrumental in enabling us to undertake these critical endeavors, and for that we are deeply thankful. Lastly and finally, as I conclude my remarks, one of the things the Uganda Law Society, and we discussed it here at the last time when we met here as Rule of Law, is that the quarterly reports take 3 months. So we are now going to have Rule of Law monthly digests to ensure that we are monitoring at a monthly level. So the Rule of Law monthly digest will then be able to be consolidated into the launch of the quarterly law report. So as Uganda Law Society, starting next month, we are going to have monthly Rule of Law digests. So I want to thank you all for your attention and your commitment to the cause of justice. Together, let us work tirelessly to ensure that the rule of law remains the guiding principle of our nation's journey towards progress and prosperity. God bless you, and thank you.
Thank you very much, Bernard. Ideally, we should have, according to the program you received, we should be having a plenary session, but would like to change that a little bit and have the launch itself taking place. I'm going to ask our technical team, our administrators. I think there are some copies of the report which you would kindly share with our distinguished guests and partners in the fight for rule of law and good governance. Please, if you could start with the high table, it would be very good. Thank you. So members, as you receive a copy of this rule of law quarterly report, the second quarterly report for this year, I'm going to invite President Bernard and a select team of our dignitaries to kindly step up where I am, and we can then launch this report. If there are some comments that Bernard you'd like to have either of our dignitaries make, please, that is also within your purview to do so. After that has been done, we shall then sit back and have a plenary session, and then we shall start winding up so that you can go and finalize what is remaining of the day. Bernard, please.
Thank you. Thank you, Dr. Daniel Ruhweza. Let me ask the ambassador to come and help us launch this report. Let me also request, with your report, please, let me also request the Solicitor General to. Let me also request the Senior Technical Advisor. Let me also request the representative of the Royal Danish Embassy. Let me also request the representative and head legal CID. Let me also request the representative of the IGG and deputy IGG. Usually we have a place where we sign, but today we shall make it very simple. We shall just hold it as a sign of launching the report. This is the State of the Rule of Law second quarterly report, April to June 2024. So we shall just hold it up as a sign of launching this report.
Yeah, President, you should be there. Ambassador, would you say a few words, please?
Thank you very much for the invitation. I always very much feel honored that I'm invited because I think that the rule of law is just so fundamental for every country around the world. And being trained as a lawyer, I understand this maybe more than the average citizen. And what I appreciate is that, as the President said, both sides are underlined the progress that has been made and the challenges that remain. And what I also particularly appreciate is that there is dialogue, that normally the police, UPDF, security people are here to discuss certain issues, and that this is so essential, this is so fundamental, that you remain in dialogue, that you don't just communicate through the media, but that you talk directly and say, this is where we have a problem, how can we solve it? And I think that the quarterly year of law rule of law report is a very useful instrument to encourage this sort of dialogue. Thank you very much.
Thank you very much. I'm going to also ask Solicitor General just a few comments from you, and then we'll launch this report. Thank you.
Thank you very much. Good morning, everybody. I'm here in two capacities. I'm here as the Solicitor General, and I'm also representing the Honorable Attorney General, who couldn't make it. The other assignments that were pre-arranged. So he requested me to come and represent him. And what the President just talked about was in his address. He recognizes certain challenges. But as the head of the bar, he's also cognizant of certain changes and certain developments that government is taking up. One of them is that in the recent past, there were amendments to the Judicature Act to increase the number of judicial officers and also magisterial areas so that there's accessibility to justice in all corners of Uganda. It also recognizes the construction of the appellate courts that the President spoke about, and that is an achievement in the right direction. The rule of law is a concern to everybody and to the stakeholders in the governance and security program, and also under the administration of justice program headed by the judiciary. So we are comrades for the development of the rule of law in this country, and it's the right of every citizen to be accorded respect and dignity. The issues raised by the President are issues that we have all, it has been in the press, both in the media and the print, and that's a matter that I'm going to relay back to the Honorable Attorney General and say, I'll tell him that the society wants him to raise it to the government, maybe in cabinet, and those matters should be addressed. I thank you very much.
Thank you very much, Honorable Solicitor General. President, would you like to launch it now? Or would you like a few more people to say something? Yes, all right.
I think I will let the remaining guests say something after we have launched, so that they can be able to have a view of the report. So I take this opportunity to, on behalf of the Uganda Law Society, to launch the second quarterly rule of law report. We can just hold it up. Yeah. Second quarterly rule of law report, April to June 2024.
Thank you very much, our distinguished guests. Please, you may resume your seats, and then we can go on to the next session. Okay, friends, very quickly, if you look at the Friends, very quickly, if you could look at the report and just peruse it in preparation for our plenary session. There is a table of contents, and there are different issues there that have been raised by the committee. You may not have had the privilege of looking at the report beforehand, but this is an opportunity for you to do so right now. There's quite a lot that has been covered in the report, and we will appreciate your comments and contributions in that regard. While that is happening, I will then kindly request our other representatives and distinguished guests to share a few words, starting with the Senior Technical Advisor, Justice, Law and Order Sector, Ms. Rachel Odoi Musoke, to say a few words, and also to give heads up to Ms. Sarah Birungi to say something. And then we shall have Ms. Gladys Nairuba, representing the Royal Danish Embassy, to share her reflections. After that, we shall open up for a plenary, a few comments, a few questions, and responses. I had missed out SSP Isaiah Igumira to also say something in that regard. So, Rachel, over to you.
Thank you very much, Dr. Ruhweza, Your Excellency, the Learned Solicitor General. I want to first of all associate myself with the remarks by the Honorable the Attorney General and the Learned Solicitor General, the Solicitor General being the chair of the JLOS Access to Justice Steering Committee. As both the Governance and Security Program and the Access to Justice Sub-Program, the promotion of the rule of law is one of our priorities. And we look to our partners to support us in that endeavor. And in that spirit, we are always very honored and committed to continuing to work with the Uganda Law Society to promote the rule of law, but also to prepare these quarterly reports, which give us a snapshot about where we stand in terms of the rule of law. It's among the many references that we use for us to be able to assess our performance and how far we are progressing in terms of promotion of the rule of law. We take note of the achievements. We appreciate the support that we have received to be able to achieve some of these significant milestones. But we also take note of the challenges that are reported here. And we will take the opportunity to study them in depth and to have further discussions to see how we can deal with some of these challenges that have been raised. In particular, I think we note some of the challenges around the Human Rights Commission, but also around legislative processes, and we are committed to continuing to work with you on those particular areas. I wish finally just to appreciate the President and the Uganda Law Society for the decision to prepare monthly digests, which will then contribute to the quarterly reports. I think this will also give us an opportunity to go a little bit deeper into the issues. If on a monthly basis we can pick particular issues and give them a deeper analysis, we can then have a more robust quarterly report, which would help us, would provide more information and more guidance for us to make decisions as the Justice Program. So we really appreciate the work that has been done so far, and we look forward to continuing to work with you on this report. I thank you.
Thank you, Rachel. Ms. Birungi, if you would come to where I am, so that the media are asking that instead of hiding there, you would come here so that you can be easily identified. Thank you. After Sarah speaks, we shall ask Afande Isaiah Igumira to also come share a few remarks in that order. Thank you.
Good morning, colleagues. I stand here on behalf of the Inspector General of Government and the Deputy Inspector General of Government, Dr. Patricia Chanokiria, who have not been able to make it due to earlier scheduled assignments. As the Inspectorate of Government, we acknowledge the need and the importance of upholding the rule of law in our country if we are to succeed in everything that we do. And if you may note, one of the functions of the Inspectorate of Government is to foster adherence to the rule of law and elimination of corruption. This is a joint effort that cannot only be done by the IG, but all of us as stakeholders. We each have a responsibility or a role to play in enforcing the rule of law. It starts with you and me to ensure that the rule of law is upheld. I would like to say that as we enforce and do that, we should be mindful of the rights of individuals in our daily work that we do. Individuals have those rights that are not derogable, and we must ensure that we uphold them. I've been flipping through the report, and I've seen one of the matters that were handled by Justice Wamala Boniface, where he awarded some damages to individuals who were incarcerated for more than 48 hours. I would like to say that it's very important that as we do our work, as we take our country forward, we uphold those rights that people are entitled to. We very well know that we are all innocent until proven guilty. So we accord that to individuals, even when we think they're on the wrong side of the law. Let's leave that to be done by the institutions that have been put in place to determine the innocence or the guilt of those individuals that are found in default of the law. Without saying much, I would like to thank the Law Society for putting together this report and request that we go forward to have more reports and bring out those challenges that we face in the course of doing our work, as well as acknowledge the achievements that have been made. It's only when we make enough noise, if I would say, or if it's only when we make it known clearly that we should have the rights of people upheld that we shall be able to uphold the rule of law. Thank you so much.
Thank you, Sarah. As Afande comes, I'm going to read out a very small poem here. It is entitled Amateka. Amateka is the Luganda phrase for what? For laws. The law is like my mother, caring and protecting, keeping away the bully and locking up the insolent. Yes, like the mother hen, the law will not discriminate. It will wrap us all, regardless of tribe or color. Under its wings, it keeps us safe. The law is like my favorite avocado tree. At some point, it grows old, weak branches drop off or are pruned. All new ones are grafted, bringing youthfulness and vibrancy and variety. The law is like a mystery. It needs to be taught to all and sundry, that they might protect it or guard it or explain it after knowing its value. The law is like the mountain in the background, or that mighty hill in the foreground, protecting us from the harsh elements, yet providing the necessary climate to keep us cool, orderly, and humble. Yes, the law is like water. It washes, it cleanses, it renews, it gives hope and new chances, it reforms and rehabilitates. The law is like the sap of the black jack or the salt from Lake Katwe. It preserves, it heals painful wounds and keeps away the sepsis or decay and rot. The law is like the foundation, expensive to lay, but ensures generations of stability. It is like the tree in the compound, a necessary evil, frustrating the game of football, yet creating shade for the elderly, climbing room for the toddler, and resting place for the birds, who also bring more seed to plant. The law is a necessary inconvenience, a huge reminder of the values of sanity. For Thomas More, he would rather keep in its forests than cut them down, lest he has nowhere to hide. Beware of those who want to cut down the huge mango tree that has lasted generations. Be cautious of those who want to flatten the mountain of memory, truth, and justice. Let the law be inconvenient but necessary. Thank you very much. Afande, you are welcome.
Thank you, Dr. Weza. Allow me to ride on the previous protocol. I'm Superintendent of Police, Igumira Isaiah. I am the head of legal and complaints at CID headquarters. Recently, my department was added another department of complaints simply because we wanted to address some of these complaints that arise. And in the wisdom of the leadership of CID and the police, they realized that some of these complaints can better be handled through the legal department. Mr. President, I want to congratulate you and your team for launching the State of the Rule of Law second quarter. And we associate with your team and you on whatever you are doing to make sure that we have a decent community. Now, there are very many things which are raised here, and of course, because of time, I don't think I can address each and everything. However, there are certain things we can discuss and see. In the opening remarks of the president, he talked about the access to justice, to more courts, where more magisterial areas have been opened. And for us as CID, we normally say, access to justice begins with us. Police is the first entry point of access to justice, the criminal justice system. So we would want to have stakeholder engagements so that as they open more magisterial areas, we also have now more police stations. We have more CIDs who are nearer to these magisterial areas, because who will feed them? If you look at the DPP, talks about understaffing, because we don't want a scenario where you have court, but you don't have officers who are going to investigate cases, and you don't have DPP that is going to prosecute those cases. So for us as CID, we normally talk about stakeholder engagements. So at some of these things, we address them the way they are. Because once we have presence and we have courts which are in those areas, then what about also the CIDs to investigate some of these cases? So I think that as a directorate, we are open to discussions, we are open to criticisms, we are open to critique, and we are open to feedback, however brutal it is. More often than not, we have held our officers responsible for some of these violations, especially if they have been done by an individual. We are an institution that does not condone human rights violations. And every time we are in our forums, we talk about it. We talk about illegal arrests. We talk about premature arrests. As the Department of Legal, we have gone around the country teaching our CIDs to avoid making unnecessary arrests before they investigate a case to a certain level. Because these are human beings. Sometimes they can make mistakes. So we normally tell them, don't make unnecessary arrests or premature arrests. And Ugandan society, I would also want you people to come and give us a hand. You can do pro bono. You can come and we agree on the schedule, on how you can get your members who can even come and teach, who can come and lecture our officers in the force about some of these laws. So as an institution that is willing to uphold the rule of law, that's why we always want to be in these engagements, so that we can get honest feedback, so that when we go back, we have self-reflection. Where have we gone wrong and what have we done right? And if we have done it right, how do we improve? Because if a community has many human rights violations, it affects all of us. It doesn't affect a section of people. And I want to thank the president of Ugandan Society that we have had several engagements with this society. We have talked to lawyers who even come to police stations and criminalize civil cases. We have talked to the society. We say, no, much as we have these detectives who might be compromised, but sometimes it starts from us. If you look at cases of obtaining money by false pretense, if you are to go into deep, you realize that a lawyer somewhere has confused the detective into believing that there is an ingredient of a criminal case, whereas not. And we have these open discussions. We tell them, no, counsel, surely, why don't you handle this case of your client in a civil court? Civil courts are there. And the most excuses you give, you normally say, you see, the other one is longer. So what do you want us to do as CID? How do we shorten the civil process? So these discussions, to me, are healthy and they are helping us. And if we have these continuous discussions, we can have a better society. So because of time, we might not have lengthy discussions, but we are open, we are there. We have opened up a complaints department. We even have an email address we are going to launch. End of this month, we are going to launch a call center for CID where the citizens can actually even call direct to raise some of these issues. So once we do that, then we can be accountable. We believe in accountability and we believe in transparency. An institution like the police and the CID where I come from, if you are not accountable, you cannot serve people better. If you look at the current fight against corruption, it is our determination where we say no, irrespective of who you are, irrespective of what you are, please, you go and answer to the courts of law. You take your evidence there. So once we have your prayers, once we have your support, then we can together develop our country. I thank you.
Thank you very much, Counsel. You may think he's just an afande, but he's also Counsel. All right. We are going to have a plenary session, but before we do, for purposes of those who are watching us online or for purposes of the press, when we are talking about the rule of law, we are talking about a principle of governance in which all persons, and I must emphasize that, all persons, institutions, and entities, be they public or private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international law principles. I would like to emphasize that we are looking at a principle of governance in which all persons, institutions, entities, public and private, including the state, are accountable to law. Oftentimes, we tend to emphasize and speak to the state and forget about the public or the private individuals or institutions. In essence, what I'm saying is that we all have a role to play in ensuring that the rule of law is respected. I'll then take you very quickly to duties of a citizen, Objective 29 of our national objectives and directive principles of state policy. Objective 29 clearly says the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations. And accordingly, it shall be the duty of every citizen, A, to be patriotic and loyal to Uganda and to promote its well-being. B, to engage in gainful work for the good of that citizen, the family, and the common good, and to contribute to national development. C, to contribute to the well-being of the community where that citizen lives. D, to promote responsible parenthood. E, to foster national unity and live in harmony with others. F, to promote democracy and the rule of law. To promote democracy and the rule of law. That is a duty of every citizen to promote democracy and the rule of law. And G, please take note of G. G says to acquaint himself or herself with the provisions of the Constitution and to uphold and defend the Constitution and the law. This is your Constitution Objective 29. With that said, therefore, we still want to appreciate the state or the government as represented by its various bodies, the police, the Attorney General's office, our partners, JELOS, our development partners as represented, the IGG and others. I also see I'll say my former classmate, Dr. Rose Karugonjo, who is now holding a powerful office, chairing the Leadership Code Tribunal. We recognize you. Thank you for being with us today. We recognize all the efforts that have been made. Afande Igumira, when I clapped, I was clapping because police is now responding to the highlighted issues that the Uganda Law Society has been reporting upon. Please, let's give the police another hand clap. In another school, which unfortunately is not as good as the one I went to, they say Gacha Alimabaga. Is that what it's called? Eh? Gacha Alimabaga? And is that the phraseology of the school? Which means that? Pardon? Yeah, there is much more. There is much more that needs to be done. That is the school that, well, yeah. There is that other school. There is a better one which I went to, but that was its motto. The one I went to says, "For God and my country." So the plenary session now commences. The president, Uganda Law Society, has asked me to hold forth on his behalf. So in case there is any check to be signed, you can look for me right now. I knew that many people wouldn't get the joke, but it's okay. All right. Questions, contributions, responses. Anne, I'm going to come to you, but let's start with Mr. Musisi, because I've seen him burning for the last 30 minutes. Otherwise, he might hold me in problems. After Mr. Musisi, Anne, you'll come through, and then we shall have Mr. Cheyune. Mr. Musisi, unfortunately, you'll have to hold forth. There is one more senior than you, Mr. Peter Walubiri, who taught all of us the law. Allow me to approach him first. Otherwise, we will be badly behaved.
Thank you, Dr. Ruheza. You and your colleagues should remember that there is a duty to pay ndobolo to the teacher annually. I'm glad for the efforts of the Uganda Law Society to contribute to the rule of law debate. Now, the rule of law, and Dr. Ruheza, you are referring to Objective 29, is really intertwined with democracy. You cannot separate the two. And that's why I will not make much comment on the violations on the rights to freedom of press and expression, the threat to academic freedom, the prosecution under the Computer Misuse Act, the violation of the rights to freedom of assembly, all those that are still rampant in this country simply undermine the low levels of democratic dispensation in this country. And they'll not be solved through the sphere of law per se, but in a broader democratic process. And I don't know what the Law Society will contribute to that, but as citizens, until we deal with the governance deficit in this country, which is growing, I will not be able to deal with these violations that I've highlighted. And that debate will transcend beyond this room and cascade into politics. So I rest it there. The president highlighted some achievements, or what he called achievements, in the rule of law, notably commissioning of new building for the Supreme Court and Court of Appeal, the instrument which opens up new magisterial areas that would improve access. But as Afande Igumira mentioned, see, the mere fact that you have a new court does not per se translate into justice and rule of law. For example, if there are no investigators, there are no prosecutors, the magistrate may sit there and the lone overburdened police officer stands up and say, "Your worship, investigations continue." So the matter is adjourned for the next 30 days. When I was still practicing criminal law, and that's one of the reasons I really stopped. The prosecutor would just stand up. Every file they call, investigations continue. Further remanded for 30 days, or bail extended for 30 days. Mention after 30 days. I don't have the police file. You know, this prosecutor would have like 40 files and is mentioning the same thing. So yes, you have a magistrate, but you don't have investigations, you don't have what? So you may open a new Supreme Court building and a new Court of Appeal building, but what is the quality coming out of those buildings? For once, do we have enough justices? And if we have the numbers, what is their output? Incidentally, I went to the Supreme Court building, we inspected it, and I saw the gym, I saw everything. Then I saw a very tiny physical library. I hope they have a bigger virtual library, because the library I saw there is smaller than the one we used to have in Mengo. So yes, you may have new buildings, you may have new magisterial areas, but I hope the Law Society will continue to monitor and see that we don't have a repeat of UPE in the judiciary. There is only one violation and one right that I want to address really. The right to property. Recently, there have been big headlines when they have been chasing people from the wetland. And the Law Society in this report deals with that issue, I think at page 28. And says there should be a balance really when people are being evicted, really calling for humane treatment and so on. But there is a very big fundamental issue here. Not only in Rubiji, but elsewhere, especially where wetlands were declared over private property. People had property before 1995. You declare them wetlands, and we need their protection. So the range of activities you can do are restricted by the NEMA Act and regulations. You can do some fishing, you can harvest grass for making baskets and so on. But this is property, say, in Kampala. The next plot, just before the wetland, somebody has put up a high-rise building. He can earn 100-fold from his plot. Me, I can't earn. I have my title. My land is being used to provide environmental service to the community. Just like my land could be used for purposes of a road or for purposes of transmitting electricity. Why don't we engage in a robust debate about compensation for people whose land we want to restrict use as wetlands? Because the land is assisting us, all of us. I really think that to the extent that I can't use my land where I have a title in a wetland commercially, my property has actually been expropriated by the government or the public. I've been discussing for a year with the client, why don't we file a constitutional petition along these lines? But the client doesn't make up his or her mind. So I have no client. It's a matter we needed to test out. But what do we do with people losing property so that we have a healthy environment? Should they walk away without fair and adequate compensation? I think it's an issue that we needed to discuss. Thank you.
Thank you very much. Mr. Msi.
Thank you, Dr. Ruhweza. Just two comments from me. One, I want to begin by associating myself entirely with Councillor Rubiri's issue on the relationship between the levels of democracy and the violations of some of these rights. But my comment, one goes to the continued abuse by security agencies of the freedoms under Article 29, the freedom of conscience, expression, assembly, and association, especially. Many times we are in these meetings, and Councillor Igumira represents security many times together with many other colleagues of his who have not come from police, the army, and so on and so forth. And sometimes we tend to ask how far do they go in giving legal guidance to their colleagues out there? Because it seems when it comes, for instance, to the right to peaceful protest, it has been left to the discretion of the security agencies. The president highlighted where one peaceful protester is arrested, and we've seen that many times. Even one person or two people very aggressively arrested, and then one time you see a group being led by security officers. And even when you tend to ask security, it seems it's a discretion of how and the interpretation of how each person appreciates it. You see one group of over 100, sometimes even roads are blocked, then one person cannot peacefully protest. So it seems the right to peaceful protest has been left at the discretion of who is interpreting, who is the security agencies. Similarly, when it comes to assemblies and association, the Constitutional Court has pronounced itself many, many times and quite clearly on that. But even then, it seems it's at the whims of the security, the enforcers. One time, we had a police spokesperson saying, you know, they have to be in enclosed spaces, which is something certainly outside the law. So in our guidelines, they have to be in an enclosed place. Fortunately, the new leadership overturned that. They said, so you find that the right, it seems, is at the discretion of the enforcers. So my question, and this is to Afande Councillor Igumira, because not you personal, but your office as the legal person to some of the security agencies, and because you're here, that how far do you go in guiding your troops down there in terms of interpreting, especially in what courts have said, which should be quite clear. Then secondly, and lastly, the report also highlights the continued trial of offenses under the Computer Misuse Act and the amendments. And we know that this is one of the laws which have been challenged in the Constitutional Court, and the Constitutional Court is yet to make a pronouncement on the same. Many times we've seen courts fast-tracking some of these cases, which are even both, for instance, High Court is conducting a murder trial, which happened a few months ago. We've seen the Constitutional Court pronounce itself on a law which was passed just last year. So why don't they also profile some of these cases, especially those where they are continued trials, because they may have constitutional ramifications, the Computer Misuse Act. Just imagine if it's had 5 years from now and it's declared unconstitutional, and then some people have served prison sentences. So I think the Constitutional Court should also try to profile some of these cases, especially those which have in particular use and have been challenged for purposes of having a determination once and for all. I thank you, Dr. Ruhweza, my client.
Thank you. Thank you, Mr. Msi. Yes, Anne. After Anne, we shall go to Mr. Cheyune. Yes, and then we shall come to you after. Yes, Anne.
Thank you. I would like to associate myself with the views of the previous speakers, my learned colleagues. And I think regarding what Councillor Walubiri said, I think it's important for government to carry out a benchmark, maybe on other countries. What do you do when someone's title is found in a wetland? What steps do you do? What steps do you take as government? How do you address issues rather than waking up and throwing out a group of people? And without any recourse or remorse, I think this is a call on government to try and benchmark, because it's part of good governance principles, to say, well, how are other countries doing it? Then for my two comments that I want to make, one of it is a call on government to respect the independence of the judiciary. We have seen recently in the media where people or political persons are granted bail by government. Then within the principles of court, security agencies come and rearrest them. Really, that is an attack and an abuse, a gross one, on the rule of law. And when courts are desecrated, then we are going back to the medieval times. We cannot sit and go about as if it's business as usual. That means we have no courts of law. Yes, you're increasing courts, but respect the independence of the judiciary. Otherwise, what does it help us to sit here and applaud the government for increasing the number of courts, but yet courts are rendered impotent? Yeah? They cannot do their work. If a judge makes a pronouncement and government says, no, we do not agree with you, we are going to, do as we see fit. So mine is a call on government. Then secondly, as we applaud government for the increase in the number of courts, I am also calling for specialized courts to address the issues of victims of gender-based violence. As we all know, there is an issue of backlog in this country. You see, even right now, judges are on sessions trying to handle thousands upon thousands of cases. So these issues, matters of gender-based violence that are on the rise, need specialized courts for the victims. Otherwise, you find out that they will lose trust in the system. Many of them, feel victimized. They cannot appear in public courts or in the ordinary way, the way we handle other criminal matters, Then also the matters pertaining to that are, call for specialized handling and expedition of justice. Yes, I thank you very much.
Thank you very much, Anne. The Honorable Solicitor General, maybe you'll give a response to Anne at some point in time. I'll give you some time to prepare a response. Mr. Cheyune.
Thank you, Doctor. Maybe to put the record clear, I'm Paul Muchivi. Cheyune is my partner.
Cheyune is your partner,
yes,
sorry.
Thank you.
And yet we know each other very well. Yes, Mr. Muchivi, go ahead.
Thank you, Doctor. I represent the Director, LDC. I head the Department of Law Reporting, Research and Law Reform at LDC. My attention is on page 39 of this report. ULS had made some recommendations to perfect the rule of law. Specifically, I want to highlight case backlog. The recommendation is recruitment of more judicial officers. I think we need to put our ears on ground. Every year, there's been elevation or increment of judicial officers, how is this translating into reduction of case backlog? I think we need also to address more other real challenges. One is laziness of judicial officers. If you are not a practitioner, you may not understand this. We are in court, you argue a simple application, it takes 2 years, no ruling. You finish a matter, 3 years, no judgment on notice. What is causing that? I think we need also to carry out some statistics whether increasing judicial officers translates into reduction of case backlog, or there are other underlying factors which need clear address. Related to that is maladministration. 2-3 years ago, Luwelo High Court Circuit was operationalized. When it was operationalized, so many cases in other circuits were transferred there. One example, land division, which has 9 judges. Files had to be removed from the different 9 judges and taken to Luwelo, where there is 1 judge. Family division, civil division, commercial division, all transferred back, cases originating from Luwelo, to 1 judge. The files are coming from a total of about 30 judges. And the judge is just overwhelmed. You go to hear a matter, you get an adjournment of a year ahead. What justice is this? Adjourning a case a year ahead, and there is no guarantee that when you come to court after a year, you will be heard. You reach there, the judge is out of the country, the judge is on leave, the judge is handling a criminal session. I think we need to really fix interim measures. Such a court, you cannot get justice, and mob justice is going to be the solution. Because most of the matters there are land disputes, and people are not getting justice. It is delayed, no hearings, just adjournments. So I think these are underlying issues that need to be given attention. Why did you have to transfer files that already party had before so many judges to 1 judge before we create a plan in that court circuit? I think those are issues we need to really address. The last one is on page 37. Page 37 talks about some laws that are pending, or bills, sorry, let me call them bills that are pending. We also need to have a clear study. I'm now 16 years standing in practice. I joined law school way back in 2001. There was what we called Domestic and Relations Bill. It is appearing on page 37 as the Marriage and Divorce Bill 209. The bill is just changing fashion and names, but it remains a what? A bill. We are clocking the 3rd decade. It is a bill before Parliament. What is Parliament doing? Are we serious? If we cannot legislate a bill, why don't we shove it off? Because so many years of a bill, and there are underlying issues why this bill was proposed. Why don't we get clear studies, clear reports? What is failing this bill to become a law? Is it a fashion of just changing names, and you have another decade, also change a name, another decade? There are issues we need to really put straight forward to really have justice at play. Thank you.
Thank you very much, Mr. Mchibi. Some of the questions you have highlighted, the points you've highlighted, maybe the Law Society will take them on, and then maybe the last question that you have discussed, hopefully the Honorable, the Solicitor General may have a comment on that marriage and divorce bill that has not yet been addressed. Okay, well, let's take one more question, and then in case there is anyone else who wants to respond, you could respond, and we shall be starting with the Honorable, the Solicitor General. Yes, one more question, and then we shall ask Honorable to say something.
Thank you very much, Doctor. I also want to associate myself with colleagues who have already submitted. Mine is the rule of law in this country. If you are living in Kampala like I do, probably if you don't have self-control, you will die of high blood pressure. You are moving in Kampala, you see an educated gentleman driving a car, getting rubbish out of the car, throwing it outside. The border guys are like that. The question is, what has gone wrong? When you make a clear analysis of our society, you will realize that our society has actually lost rationality and morality, and now we are at a level of compliance and enforcement. And that is where the challenge is, that even the police officers who are arresting people, they are not rational in what they are doing, and they are not moral. But also the society itself, you realize somebody says this is a wetland, constructs there. But even NEMA is not rational in implementing the law. So that is a challenge when you are dealing with a society that is not rational, that is not moral, and you have to live in that society. It becomes more worse if you have to implement the law in that kind of society. The question we have today, probably, what can we do? The Uganda Law Society had started on it some times back, had started the law clubs in schools all over the country to teach, to encourage the younger people in our society to be law-abiding citizens. And probably we bring up a rational and moral society that respects the law. And unfortunately, in this report, I have not seen anywhere where that effort is continued of bringing up that kind of society. Dear colleagues, all we are complaining about, in my view, is because of lack of rationality and morality. You employ the judicial officers to go to court and work, yes, but they will not go there to work. They want the salary at the end of the month. You employ police officers and you train them in the police code of conduct. But when you deploy them, what they do is contrary. This is neither, this is a challenge, because even the next government will have the same society to recruit from. Even this government, sometimes we blame it, but it is recruiting from the same society that is immoral, that is irrational. You recruit teachers to go and teach. You pay them salary, they don't go to class. You recruit doctors to work, they don't go to class. Nobody they don't go to the hospitals. Nobody seems to respect the law. So we need to come back. I'm calling upon Uganda Law Society to strengthen the clubs, to go to the grassroots, to make sense, to sensitize the society about the importance of the rule of law, and probably the next generation will benefit from our efforts. Dr. Submit.
Thank you very much. Just to respond, on page 48, you will see the launch of King Caesar University Rule of Law Club. So Godias and team are continuing to do what you're saying that they ought to do. So could someone kindly share the microphone with the Honorable the Solicitor General to respond to some of the issues that have been highlighted, and then we shall also give SSP Igumira to also respond to some of the issues that have been raised regarding the police. Over to you, Honorable the Solicitor General.
Thank you very much, Chair. Number of issues have been raised here. Of most concern is the wetlands. wetlands, the issue of wetlands has been there. If you follow the development of the environment worldwide, starting with the Kyoto Protocol and the rest of it, many countries have joined in the fight to preserve the environment. And we have it in our constitution. It is everybody's right to protect the environment. We have the NEMA law, we have a number of regulations. As I speak now, the wetlands have been gazetted, but maybe it has not been publicized enough. All the wetlands in Uganda have been gazetted, and I have a copy. And under the NEMA Act, we are supposed to avoid degradation of the wetland. Whether other people are there or not, that's another matter. But foremost, as Uganda Law Society, we should actually be educating people on the use of the wetland. And we have made statements this morning that the law must be respected and protected, irrespective of somebody's position in life. So the laws are there. We are not supposed to construct in the wetland. The other day I was going to Chankwanzi and I passed Lubigi. I remember those houses were not there some time back. I don't know when they were constructed. Maybe the method of eviction. But we have had discussions about people who are in the wetland. And Cabinet came up with, I'm not a spokesman for Cabinet, but what I know, we advise. And we said those titles that were issued before 1995 Constitution, those ones will be compensated. But those people who got the titles after the 1995 Constitution will not be compensated because they're supposed to know the law. Everybody is supposed to know the law. The fact that you didn't go to school, you never read this is another matter. It cannot be a defense because the law is supposed to be obeyed by all persons. So, under the NEMA Act, the wetlands are supposed to be preserved and used only for certain things. And you must get a permit. I had the executive director the other day saying that they may not give the permits because it has been abused, but that's another matter. Having said that, I would say the wetlands are supposed to be respected. I don't think there's any compromise about that unless the laws are changed. Because there are a number of things you can do in the wetland. You can do fishing, you can do agro-farming, you can do a number of things as long as you preserve the wetlands. And that is after getting environmental impact assessment. That's one. On the issue of the marriage and divorce bill, this was a private member's bill, and there are a number of things that are supposed to be followed when the private member's bill is brought up. But then there were so many concerns that it became political. Number of issues were raised. We have discussed it severally, how it should be handled, but it has not yet been tabled. I don't know why it has not been tabled. There are other laws that are pending. I think for one reason or another, there are issues that may... let me give an example of the legal aid bill. We did a costing, and I do not know how much it came to. And Mr. President, I think next time when we are coming for such important discussion, I think we should be given this report prior so that we come with concrete answers to come and discuss with you with evidence, because now I'm just trying to remember some of those things that were discussed, some of the laws that were tabled in Parliament, and I don't remember the reasons why they have not been concluded, but all the most important laws have been taken into consideration. One of them, of course, Mr. President, you spoke about, that the magisterial increase of magisterial courts, despite the challenges that comes with it. But all those are being taken into consideration. We talk about human rights, the Human Rights Enforcement Act, making officers accountable for their actions. You see, we are all supposed to be responsible for our actions. You can't hide behind the state because the citizens are empowered to take you to court and say, you did this and that, irrespective of your mandate, maybe under the Police Act or under the UPDF Act, but you went beyond, and a reasonable person is supposed to know what they're doing. For example, under the command control responsibility. A commander cannot tell you to shoot somebody and kill them. You will be responsible. You, as a reasonable person, you should have known that this person, first of all, has not done anything, and then you do not have the powers to shoot and kill unless you are in war, you are at war. That's when you can kill, because you are lances to kill when you are fighting. And you only kill when you are in full combat. When a person has surrendered under the Geneva Conventions Act, you are supposed to treat him as a prisoner of war and not harm him, actually protect him. And at the end of the war, repatriate him to his home country. So there are certain things that it depends on the individuals that are doing it. It doesn't depend on the law. The law provides just parameters upon which certain actions or certain enforcement should be permitted. But if you go beyond that, then you are responsible. I do not know if there is any other thing that I did not respond to.
Thank you.
Arrests.
Something to do with the arrest on the court premises,
again,
independence of the judiciary.
Again, I think that is individual action. If you are told to arrest somebody, you should find a convenient way of arresting that person if you're given that instruction. But if you grab a person, throw him down, sit on his back or on his stomach, that is not the normal way of arrest. That is an arrest which is not allowed under the law. The law does not prescribe how you should arrest, but the law presupposes that a person who is given such powers is possessed of common sense that he will use while arresting an unarmed person, or somebody who is resisting arrest. So he should use reasonable force. And I think somewhere it is mentioned reasonable force. And if he resists, maybe you also use reasonable force to restrain him. For example, if he is fighting, maybe you can disable him. Police officers are taught how to disable people's limbs without destroying them, just paralyzing them, beating the joints, and then the fellow sits down. But if you hit the fellow on the head, that is not reasonable force, or it defeats all common sense. If you hit somebody with a hammer on the head, you are not just arresting him. That is attempted murder. So really it depends on the people, on the officers and agencies that are mandated to enforce certain obligations. I thank you, Mr. Chairman.
Thank you very much, the Honorable the Solicitor General. I will ask SSP Afande Gumira to also make some responses. I think Mr. Musisi raised some issues, among others. Thank you.
Thank you, Doctor. Thank you, Honorable Solicitor General. Actually, he has answered most of the things Musisi raised. And being a lawyer of government, what else should I add? But nevertheless, what we should understand is that there is also a principle of contradictions. A law is made to cure something, but then it also creates a contradiction somewhere. Now, that does not mean that you are supposed to violate a right, someone's right. It means that the officer who is on ground is supposed to exercise reasonable judgment. So you can imagine how the situation, you are supposed to exercise reasonable judgment. Now the question now is, who should judge your judgment? If I make a judgment, if I'm enforcing the law, that there is a right of assembly, but in ensuring that law, also you who is supposed to assemble, you also have other requirements that you're supposed to uphold. So if you do not, it means that I will also use the same law to enforce. So that's where there is conflict. And if you look at man naturally is a political animal. So many people want to hide under the law to endorse their political interests, and also that creates a conflict. So to me, what I can say is that we should always be given a chance to exercise our judgment, which is in most cases fair, but in the event that something has not been done right, it can be corrected, and the person who has done it deliberately, also there is a law now to manage that person. And my brother has said it. You know, we have many dishonest people. But in this room, I can say you people are not dishonest. Even the ones who are online are not dishonest. But we have a culture of dishonesty. There is a member of parliament, I think that case is concluded. There is a member of parliament we arrested and arraigned in court over theft of iron sheets. But the next day, the same member of honorable minister now dragged the CID to court. That you see, my human rights have been violated. That these people have tortured me. But when we looked at this case, we realized that the person wanted to, I think the interest was to interfere with the other criminal case, because they know that once you raise issues of human rights, then prosecution is stayed. So all those are tricks. All those are tricks. So we had to waste resources, we had to waste time to go to court and explain, bring evidence how the person was arrested, how we sent summons and the person did not respond to summons, how the person moved from point A to point B, how the person was put in detention, how we even got a new mattress for that person, how we even got a mosquito net. What else would you want? Does human rights mean that if you are a suspect, allegedly to be a VIP, should we gazette Serena as a detention, a detention facility? Or we shall use the facilities we have? So as we discuss some of these things of human rights violations, rights to assembly, also put in consideration the rights of also other people who are not party to your reasons why you want to assemble. I think that's what I can say for now, but if there is any other thing, for us, we are always open. I have said we can address some of these issues. There is no reason why we shouldn't. Thank you.
Thank you very much, Afande, and also Council. There was a question behind you. If we could just capture that question as we start winding up. Please, let's give you the microphone so that you are properly heard. Thank you.
Okay, it's not really a question, but an observation. Yeah, first to thank the Uganda Law Society for keeping tabs on the rule of law. These quarterly reports are really helpful. I have just quickly gone through the report. Page 19 caught my eye. it was talking about, one of the points is about the alarming incidents of theft and assault, and the recommendations that have been made. And to me, the recommendations are more looking at these assaults when they have happened. But I think as adult Ugandans, maybe we should also be looking into the root causes. You know, what is really causing all these thefts, all these assaults? Partly this is due to unemployment. And when you look at some of the analysis on employment in Uganda, clearly the projections are saying that there's going to be an increase of unemployment. And I think we need to be addressing ourselves to, you know, the root cause and how to address the issue of unemployment in the country. So for me, I think there is need to put, you know, some emphasis on, you know, the preventive measures, as opposed to, you know, when the crime has actually happened. So not just for the Uganda Law Society, I think for all of us as duty bearers, as adults in the country, I think it's important to look very seriously into the issue of, you know, unemployment and how it can be responded to. Thank you.
Thank you very much. We are now going to start the process of concluding our program today. Excuse me, and I'll be asking the president to get ready to give his concluding remarks. Before I do that, I'm told that there may be one or two comments that are in the chat room and would like to recognize them. So if there is somebody who can help us find what those comments are, we would at least read them out for members to deliberate. Mr. Muchibi raised something to do with backlog, the judiciary being at one point overwhelmed, and yet at the other point, I think he called it laziness. President, maybe you can make a comment about that as well. I know that we have about, at the High Court, maybe about 200 now or plus 200 judges. There's been a steady increase in the number of judges at the High Court. But the population of Uganda is also over 45 million people. So when you see the number of judicial officers and then the number of the population in Uganda, it would mean almost one judge to, I don't know, quite a big number in the population if you look at the statistics. And President, I was thinking that maybe we need to start advocating more for a sieving process of some of the matters that are brought before our judicial officers. Matters to do with theft of matoke, applications upon applications upon applications. Maybe a sieving system should be done. You know, maybe borrow from what the ICC does and says we'll only deal with a certain class of case. But I guess the conversation between the Honorable, the Solicitor General, and the Uganda Law Society can continue happening to find a way in which you don't clog the judiciary with so many cases, and at the end of the day, people complain. And yet there are other spaces where we can have adjudication done, either at the LC courts and so on, especially those matters that deal with simple theft. I know that, for example, the police, please send the microphone to the Honorable Solicitor General. I know, for example, when you look at children in conflict with the law, you find a policeman has to transport a child from Umbale in order for that child to be held in custody at Naguru Remand Home. And you know, some of these things I think can be dealt with. So let the Honorable Solicitor General say something to that, and then if there is any comment here, I'll read it and then ask the President to come and conclude this conversation. Honorable Solicitor General.
Thank you, Mr. Chairman. There's something that I forgot to say about congestion in courts. What the judiciary has adopted is alternative dispute resolution mechanism. And the judiciary has accredited about 48, I forgot the number. I'm one of them. And senior technical advisor is also one of them. And a number of cases are being handled and being settled through mediation and also plea bargaining. And the judiciary intends to reduce the number of case backlog of over 3,000 or something. I don't have the exact figure, but that is one of the innovations that has been introduced by the judiciary to reduce case backlog. That's what I wanted to inform this meeting about. Thank you.
Thank you very much, Honorable Solicitor General. Mr. Muchibi, I think we should also start thinking of supporting ULS with a report on other innovative ways, which then the ULS can, forward to the Honorable Solicitor General, the Attorney General's chambers, and the judiciary to help resolve and borrow from other spaces. So just a few comments here. Echipu Johnson Elvis says, compensation for wetland occupants. Can an individual lawfully own a wetland? He asks the question. I think that you can hear from his from the tone of his punctuation that he cannot believe that is possible. Christine Adong says, can someone please explain why NEMA appears to be selective in its enforcements? In Nalia Valley, just below Quality Supermarket, which is a swamp corridor, we can all see construction works in progress. Is this one justified? What we normally do at the Uganda Law Society is that some of these comments are then forwarded to the different actors. So we shall share those with them. Good morning all. We thank the ULS for the 29th Rule of Law Quarterly Report. Geraldine, yes, this is Geraldine Akubu from Uganda Law Reform Commission. We thank ULRC for being with us online. Our senior counsel, Paul Muchibi, Kasule says, has put it clear. The level of laziness is so high. Some judges don't fix bail applications in capital offenses. When lawyers insist, they only fix to deny, and you wonder how someone spends 10 years on remand and the abuse of presumption of innocence. I think he hasn't finished that. But yes, let that conversation continue. I think a response can be made or has already been made in that regard. Thank you very much for those comments. I think I have read all of them. I'll now ask the President, Uganda Law Society, to come and conclude this conversation. Thank you very much. After he has spoken, please, we shall have a group photograph. The team will let us know where, and then we shall have, there is tea which has been prepared for all of you who have attended physically. Thank you.
Thank you so much. Let's applaud our MC for doing a very good job. Dr. Daniel Ruhweza is also the head of Rule of Law Committee for the Uganda Law Society. I think it's important, before I thank you all for coming, to just make a few responses to a few issues. Number one, on the issue of Lubigi, we are saying put human rights at the center of environmental protection. We agree with you, government, that the environment must be protected, but let's put human rights at the center. And that is also contained in the NEMA Act, ensuring that whatever protection measures you take, you have human rights at the center. Number two, on Lubigi, we are still saying that there shouldn't be selective application. If you're saying that we are protecting wetlands, then let that apply to everyone who is in a wetland. That is the position of the Uganda Law Society on Lubigi. Two, on the issue of right to freedom of assembly, I think we all need to reflect on the decision of Muanga Chivumbi versus Attorney General. And all these arguments that we hear police making have already been made in that case. And I think what the Constitutional Court has clearly stated is that supervision of public orders cannot be an excuse for you, first of all, to limit other people's rights to enjoy that right. That is very clear. The protection of the right to freedom of assembly is enshrined in our Constitution, and the issues of permission, the issue of suspicions that if it is political, there will be a breach of peace. The courts were very clear that if you suspect that there will be breach of peace, please go and protect. Go and protect so that there is no breach of peace. So we all just need to reflect on the decision on Mwanga Chivumbi versus Attorney General, which has looked at all the reasons that police usually comes up to deny people the right to freedom of assembly. On the issue of case backlog, as the Uganda Law Society, what we have pushed for is a performance management system, a performance appraisal system for the judiciary. And we have been consistent. We have said to whom more is given, there should be some sort of monitoring and evaluation to see whether they're actually performing. And I do not speak for the judiciary, but at least we can note that this performance appraisal management system, I think, is in the final stages, and they are taking efforts. Hopefully, as they launch the annual report of the performance of the judiciary, they'll be able to let us know how far they have gone. So, and also number two, we are also saying that there needs to be a case audit of all the cases in our courts. There needs to be a real case audit for us to be able to understand. Yes, we have had the figures from the judiciary, but we're saying we need to have some sort of independent case audit. What sort of matters do we have? Maybe some of them are not supposed to be in our courts. Yeah, and so we should also help and support in reducing backlog. So those are the two issues on the performance management system that we continue to emphasize as Uganda Law Society, to deal with the issues that my brother raised and to deal with the issues that that members have raised on WhatsApp. On the issue of independence of the judiciary, I think we've been forthright on independence of the judiciary. And I agree with my sister. You cannot rearrest on the precincts of court, because essentially what you are saying is you then don't respect the person who has made the order. So we continue to appeal to government and the Uganda police to ensure that these events don't reoccur. I think that if someone has committed another offense, there can be another process of, first of all, summoning him for that offense, instead of waiting after he has just been given bail and then you rearrest him. Right? That is not proper. Colleagues, our invited guests here, as I mentioned, as Uganda Law Society, we are now going to have Rule of Law monthly digests. I think that is going to be critical to emphasize and ensure that most of these issues don't wait for the quarterly report. Yes, we usually respond to them through statements, but in the monthly digest, we should be able to dig into some of these issues in a more detailed manner and provide responses. With those few remarks, allow me thank you, every one of you who has come. As Uganda Law Society, we continue to appreciate you for coming to support the cause of rule of law and good governance in this country. I want to thank you for your comments. I want to thank you for the time that you have spent with us. And I want also, in a special way, to thank the Solicitor General who is representing the Attorney General. I think we must applaud the Solicitor General. As His Excellency, the German Ambassador, said, it's promoting a spirit of dialogue. We can discuss these issues and see how together we can work together to support rule of law. I usually tell people that today, if you don't speak on rule of law, tomorrow it may be your day. And just always remember that we have that particular example of the Public Order Management Act. You never know when it bites. You never know when it bites. So I think it's an obligation for us to be able to speak on these issues. So thank you, Solicitor General. Please send our regards to the Attorney General. And we appreciate. We want to ask that you keep coming to these rule of law quarterly reports. And we shall endeavor to share the report so that you can have an advance perspective of what is going to be shared. Sometimes when I tell the team, they say, let's first launch it, because we have to first launch it and then it is shared. But we shall try and share with you at least a draft sort of report where you can be able to pick up the issues. Let me also thank our senior members who are here. It's important. Professor Walubiri, Dr. Walubiri. I'm no longer sure. Of the UPC party. I need to add that one. You can see as well put up the hand. When I said UPC is when he put up the hand. So thank you for coming. Your Excellency, thank you for coming. You're always here, and we want to appreciate the fact that you always attend our rule of law. The representatives of all embassies and high commissions who are here, can we upload them? Can we also upload the representatives of government institutions, ministries, departments, agencies who are here? Let me also upload the members who are online. There are members who are online and are following. And lastly, let's upload the people who put in the work, the rule of law committee. The rule of law committee. And on that note, let me also introduce our new head of rule of law at the Secretariat, Ms. Afra Pio, who is joining us from the Uganda Human Rights Commission. I'm sure you can see how we are looking also as Uganda Law Society. So we have been able to get her from the Uganda Human Rights Commission to come and provide support. Yeah, since she has been dealing with human rights for the last over 16 years. We hope that she will be able to add much needed value to our reports. Please join me in welcoming her to the Uganda Law Society. And the team, Gorgeous, and please come and wave so that, yeah, Patience, please come and come. Let's applaud them. Yeah. You know, it's not easy to put this together. Someone told me that it's easy to criticize, but you say you put the report together. You may find the difficulty to put the report together. So I want to thank the team here that has been able to, with the acting CEO who has been able to provide leadership. Please stand for recognition. Leadership is important. Without leadership, every nation rises and falls based on leadership. And that is why the acting CEO, I want to thank her for leading the team and ensuring that we deliver this. With those few remarks, please allow me wish you a nice weekend and have yourself a lovely afternoon. Thank you so much.
Thank you, President. The technical team will now guide us regarding where we shall take that group photograph. I don't know whether we remain in here. Some guidance would be helpful. In front here, all right. So Godia says that we come and stand in front. Maybe some chairs will be put for our dignitaries, and then the rest of us who are able to, we can stand behind them in order to have that group photo taken. Once it has been taken, please, there is tea in the room. So please feel free to get yourself a cup of tea so that we can also be accountable to our development partners who support us in this. All right, friends, the group photo is obviously voluntary, but I would cajole you to all participate, please. Mr. Muchibi and team, Afra, please photograph. Senior Counsel, please. Yes. The Honorable Solicitor General. We are in dire need of ladies. Only Anne has appeared. I'm hoping we all understand English. Let me try to translate Chifanani. I think, Rachel, you should be somewhere in front there, Rachel. Rachel, your seat is right there. Friends, please, let's take this photograph.